Hi, everyone, and welcome to this session sponsored by the AALS section on sexual orientation, gender identity, and the law on the recent Bostock case, which, of course, broke exciting new ground in American jurisprudence on equality for the LGBTQI population. My name is Craig Conniff. I'm an associate professor at the University of Colorado Law School, where I teach sexuality in the law, and an alum, a former fellow at the Williams Institute, and very excited to be here. I filed a brief in the Bostock case along with my illustrious panelists that are here with us today. First, we have Jessica Clark, who is the FedEx research professor and co-director of the George Barrett Social Justice Program at the University at Vanderbilt Law School. Jessica's research focuses on American equality law. She's written prolifically in numerous publications on sexuality in the law and filed a brief in Bostock, as I mentioned earlier. Next, we have Katie Iyer, who is a professor of law at Rutgers Law School. Katie is a leading expert on LGBT employment rights and social movements, and her scholarship has been published again across a wide range of top publications. She also writes, I know, in disability law, since I teach health law, and her scholarship in that area is similarly groundbreaking, as is her work in LGBT rights law. We also have Ezra Young. Ezra is a nationally recognized civil rights attorney based in New York City. While he currently maintains a boutique private practice, I met Ezra when he worked at the Transgender Legal Defense and Education Fund. He is a recognized trans rights expert and has published, again, extensively in top journals. He's litigated trans cases in courts and agencies. He won an order from the Medicare Appeals Council. He's really been in the weeds, and I've had Ezra come and speak in my class because he is particularly well versed in these areas and has forgotten far more in this area than I will ever know. So welcome to our illustrious panelists. I'm very, very excited to have you all here and to have a wonderful discussion. And we're just going to start. I'm going to shut up now and pass the baton on to Jessica. And Jessica, what are your initial thoughts on Bostock?
Well, first, I wanted to thank you, Craig and Jack Harrison, for putting this panel together, and to say that it is a real honor to be on a panel with Katie and Ezra. Ezra, I just want to note, correctly predicted how Bostock would come out long before the decision was issued. And he also predicted that Justice Gorsuch would be crucial. And Katie came up with some essential arguments against the idea that Title VII doesn't cover LGBT people because no one thought that that's what it meant in 1964. In an article in the Wake Forest Law Review in 2019, arguments that eventually made their way into the ACLU brief and then that you can find in the majority opinion. So I'm just thrilled to be on a panel with all of you. I think it would be a good idea to start off by saying a few things about the Bostock decision, and then I'd like to say what I think some of its positive implications are, and then a few words about some of my concerns about the decision's limitations. So as you probably know, the issue in Bostock was whether Title VII of the Civil Rights Act of 1964, which prohibits discrimination because of sex, prohibits an employer from firing someone for being gay or transgender. And this past June, the Supreme Court held that it does by a vote of 6-3, with Justices Gorsuch and the Chief Justice joining the court's liberals in the majority. The court's reasoning turned on a very logical argument, which is that an employer who fires a female employee because she's married to a woman, but doesn't fire a male employee because he's married to a woman, has engaged in sex discrimination. That's because the female's employee's sex is a but-for cause of her firing. But for the fact that she is a woman, her employer wouldn't have had any problem with her being married to a woman. And the court held that Title VII looks for these sort of but-for or necessary causes. It doesn't ask, what cause would you point to in conversation if somebody asked, hey, why were you fired? And it doesn't matter if there are other factors like the plaintiff's sexuality that made a difference. All that matters is that one determinative cause was the fact that the plaintiff was a woman or a man. The dissent argued that anti-gay discrimination and anti-trans discrimination aren't sex discrimination because gay men and lesbians are both being fired. Transgender men, transgender women are both being fired. So men and women are being treated equally. But the majority rejected that argument because it held that Title VII doesn't attempt to equalize conditions between groups. It protects the individual. And it offered the example of an employer who fires a woman, Hannah, for being insufficiently feminine, and then also fires a man, Bob, for being insufficiently masculine. Nobody thinks that's okay. Nobody argued an employer could do that. And so just like an employer can't punish both men and women for failing to conform with 1950s gender roles, it can't punish both men and women for being gay or being transgender. And in his dissent, Justice Alito argued that this would be terrible because Bostock would have far-reaching applications. And I think that's wonderful, and Bostock already has had some far-reaching and wonderful applications. Courts have decided to extend the decision from Title VII to Title IX, which prohibits sex discrimination in many educational programs, also to the Affordable Care Act, which prohibits sex discrimination in healthcare, to the Equal Pay Act, to the Equal Protection Clause, arguments for intermediate scrutiny for sex discrimination, and to various state statutes. One district court extended Bostock to make clear that it is sexual harassment to intentionally misgender a transgender person or to refuse to allow her to use the women's restroom or to impose a different dress code on her. Another court held that it was a violation of Title VII to subject a lesbian who is accused of harassment to a harsher standard than heterosexual men and women, which is a problem that I've seen in a lot of cases and I wrote about in a law review article in 2013. These are great results, but the formal logic of Bostock also presents some challenges. One is that it's not clear whether it covers everyone in the LGBTQ plus community. For example, an employer could argue that it fired a bisexual or a non-binary person for reasons that don't meet the but-for test. So the employer could say, I would have fired a bisexual woman even if she had been a bisexual man, or I would have fired a non-binary person no matter what sex they were assigned at birth. Another issue is that it doesn't cover every relationship. So an employer could fire a cisgender employee who's married to a transgender person, and the but-for test wouldn't apply because it wouldn't matter if the cisgender spouse was a man or a woman. There's some broad language in Bostock that might help plaintiffs in these hypothetical scenarios. And there are some other theories in the case law from prior to Bostock that could help them too. So if the employer made statements suggesting sex stereotyping was afoot, or that the problem with bisexual employees is that they're in same-sex relationships or something like that, that would help. Another strategy would be to use a provision of Title VII called the motivating factor provision, which says that it's discrimination whenever sex is a motivating factor. It doesn't have to be the plaintiff's sex, it's whenever sex is a motivating factor. But Bostock doesn't take a stance on the motivating factor provision, and I don't know that it necessarily helps plaintiffs in all those situations, which is a reason it would be a great idea for Congress to pass the Equality Act, which would cover more of these scenarios. Another issue with Bostock's formalism is religious exemptions. At the end of the Bostock opinion, Justice Gorsuch writes that the majority is deeply concerned with preserving the free exercise of religion, and that the Religious Freedom Restoration Act is a super statute, by which he means it could trump other statutes, maybe Title VII. RFRA gives exemptions to religious objectors, so employers who are going to argue that having an LGBTQ person on staff substantially burdens their religious freedom. And the question then becomes a sort of balancing inquiry, asking whether anti-discrimination law is the least restrictive means to serve a compelling state interest. My concern about Bostock is that with all of its formalistic logic, it doesn't do much to articulate what's compelling about stopping discrimination against LGBTQ employees. And so I'm concerned that when it comes time to weigh that value on a scale against religious freedom, the court is going to see religious freedom as a trump. So those are what I think are the advantages and limitations of Bostock. And I'm happy to say more in conversation, but I think that's a good place to stop with my introduction.
Absolutely. Thanks so much, Jessica. That was super, super helpful. We'll now turn to Katie. And Katie, can you tell us your initial impressions of Bostock? And if you want to react to anything Jessica said as well, you can put that on the table and we can also sort of begin the conversation.
Thank you, Craig. Thank you to both Professor Conniff and Professor Jack Harrison for organizing this panel. Like Jessica, I am thrilled and honored to be in such good company. She and Ezra are leading experts in this area. Jessica modestly did not mention her own work in this area, which in addition to filing a brief, she offered a very important explanation and justification for why the history of lower courts rejecting these claims should not be controlling. So I do want to engage on a number of the issues that Professor Clark raised, but for my brief time and introduction, I actually want to shift direction and focus on a different set of issues that I think comes out of the Bostock opinion. And in particular, I want to focus on what are the potential implications of Bostock, not just for LGBTQ litigants, but for anti-discrimination law more broadly for those across the protected classes. And first, I want to talk just a little bit about the big picture, what Bostock might tell us about the future of progressive theorizing in the context of anti-discrimination law. And then I want to talk about just a couple of the concrete ways that I think Bostock offers important opportunities to anti-discrimination litigants of all kinds. So first, what can Bostock teach us as a matter of strategy? Those of you who know me will probably not be surprised to hear me say that I think that the most important insight that we can gain from Bostock is that progressive textualism is important. Of course, textualism has traditionally been associated with right causes, and in the aftermath of Bostock, we've continued to see, or we've seen a sort of string of progressive commentators suggesting that textualism isn't truly accountable for the outcome that we see in the majority in Bostock, and that textualism is not responsible, despite the majority's articulation of that as their founding principle for the plaintiff's success here. I disagree with that perspective. I'm happy to talk more about why this is so in the question and answer. But even if I agreed with it, I would think it was strategically misguided. So we live in an era where textualism is the ascendant modality of statutory interpretation, and it is vitally important for progressives to be a part of the conversation about what textualism entails. Specifically for equality law, textualism can open up a wide variety of important arguments for civil rights reform, including most obviously providing a way to address the barrage of non-textual technicalities that currently result in the vast majority of anti-discrimination claims being dismissed. So I think it's really important for those of us in the academy as ideas people thinking about equality law to take seriously the potential of progressive textualism and to think boldly about its potential implications for our field. That's the big picture strategy perspective. I also wanted to touch just briefly on a couple of the ways that I think that Bostock already offers, quite aside from the big picture strategy, should we be focusing on textualism, important language that can be of benefit to all anti-discrimination litigants, those who are LGBTQ, but also those who are racial minorities, gender, disability, religion, across all of the protected classes. So first, although I think some scholars and advocates were disappointed that the Bostock decision did not center more directly on gender stereotyping doctrine, I actually read that opinion as a very resounding endorsement of stereotyping theory. So first, the majority opinion repeatedly relies on gender stereotyping as an illustration of its principle of what is prohibited under Title VII. And it goes further and links that principle to the but-for principle, which it treats as the central textual mandate of Title VII. Those of you familiar with this field are probably aware that sort of one of the persistent critiques that has dogged stereotyping doctrine is this idea that it is somehow not textually grounded in Title VII. So I think that Bostock's work in situating it within that textual principle is important. To give an example of how this operates outside of the context of Bostock itself, where I think the implications were obvious, if we're talking about a woman with small children who is denied a promotion because it is assumed that she won't be committed to the job because of her small children, it is quite easy to see that but for her sex, that stereotype would not have been attached, and thus that result would not have resulted, right? A man, in contrast, most likely would have benefited from the complementary stereotype that because he has small children, he needs the additional income to support his family. So looking at stereotyping doctrine through the but-for lens, I think both situates it comfortably within Title VII's text and offers a strong reaffirmation of its importance to anti-discrimination law. Second, Bostock makes clear that the but-for standard, which applies to be clear, the vast majority of anti-discrimination claims that are brought today, is an eminently provable standard and does not require anti-discrimination litigants to prove something akin to sole cause. And here I'd just like to rely on the court's own language directly. So the court opens the main part of its opinion by telling us that the but-for standard is a, quote, sweeping one, and that, quote, often events have multiple but-for causes. As they go on to state, quote, a defendant cannot avoid liability for discrimination just by citing some other factor that contributed to its challenged decision, so long as the plaintiff's protected class status was one but-for cause of that decision, that is enough to trigger the law. So despite a sort of long-standing progressive concern that the but-for standard would preclude plaintiff victories in contexts where there's sort of any legitimate consideration that was taken into account, the Bostock opinion, I think, really lays to rest that concern and makes clear that it is simply an inaccurate understanding of the but-for principle. Indeed, as the court has made clear in prior cases, protected class status need only be, quote, the straw that broke the camel's back for it to be actionable under the but-for approach. So I could go on. There's other language in the opinion about intent and the limited role of intent as well as a number of other considerations that I think really are very potentially beneficial for all anti-discrimination litigants. But since I know we want to leave a lot of time for discussion among the panelists and Q&A, I'm going to go ahead and conclude there and just say that I'm looking forward to the further conversations and to questions from the audience.
So much, Katie. We'll move on now to Ezra, and maybe I should refer to this as the Stevens case because I know you've thought deeply about that aspect of the case. But also, if you have reactions to what Jessica and Katie said, please do go ahead, and then I will try and have you all talk to each other a little more about some of your commentary, and then open it up to the audience. Go ahead, Ezra.
Sure thing. Thank you, Craig. So I wanted to make just an opening comments sort of in two respects. First, I want to sort of situate why Bostock is so significant for the LGBT community. It's obviously a tremendous win to have Title VII protections cover our community. That in itself is significant. But I think additional context as to sort of why this sort of case was brought, why advocates worked for so many decades in this really, really niche area will sort of help us understand where Bostock came from and where it might be going. And then the second set of remarks I'd like to give a little bit more concretely on what I see as the power and limits of the inclusive kind of textualism that Gorsuch deployed in Bostock. And in that respect, I'll probably pick up on a lot of what Katie and Jessica have already sort of talked about. I think we have a lot of agreement, at least on what the limits are. A little bit of disagreement on the power, but I'm interested for us to pick that up later. So better situating Bostock. So Bostock is actually three cases. Two cases brought by gay men, one case brought by a transgender woman. Unfortunately, one of the gentlemen and the transgender woman died before Bostock even was decided. And that's something for us all to sort of sit with and realize how long these cases are fought and how devastating it is that this woman was never seen by some of the people who actually suffered the horrific things that brought the case about. So why was a case like this brought? Why do people care so much? Why do impact litigators care so much about Title VII coverage? Well, for a very long time in all areas of the law, the LGBT community has basically been deemed a set of exceptional legal subjects, people who generally applicable laws simply did not protect as a matter of, in many cases, statutory interpretation. Many different scholars, including Katie and Jessica and Craig, have talked about this in a variety of contexts, but essentially this is what would happen. Judges, both state, federal, local judges, would come across statutes like employment protections, would come across name change statutes, would come across child custody statutes. And despite those statutes not having anything that expressly said LGBT people are unprotected, they would simply read it in. They would infer it into the statute as if it were a rule. So starting in 60s, 70s, and 80s, many impact litigators in the LGBT community tried to push back against this impulse. Specifically, many people advocating for transgender people thought that the breakthrough moment could perhaps be to establish under federal law that transgender people are protected by sex discrimination statutes. There was a reason why. Well, in the 1970s, oddly enough, a lot of very, very conservative jurists, as well as liberal ones, thought that a change in sex, whatever that might be, most definitely implicated sex and therefore should be a kind of sex discrimination. So it was sort of a happy coincidence, or as our critical race theorists would say, a bit of interest convergence. There was an opening there to pursue, to try to correct this sort of statutory interpretation there. So that is why the community for so long pushed on sex discrimination statutes and pushed on Title VII cases. So fast forwarding to Bostock, the issue at Bostock underlying sort of the litigation strategy at the court, as well as a lot of what we see in literature that was percolating up as the cases went up, was really, I think, an attempt to sort of correct this sort of grand error of statutory interpretation. The goal, and the thing that we eventually did get from the court, from Justice Gorsuch, of all people, though some of us did predict it, was essentially to say that judges cannot read in extra statutory exceptions into laws just because a group of people is despised, either at the time the statute is passed or currently. And that's, if you look back at the oral arguments, if you look back at the briefing, if you look back at the decisions, you can really see that as a through line throughout both sets of decisions, right? That's really, really what was at the heart of this. There were a lot of other debates, a lot of other sort of talks about, locker room access, dress codes, all these other things. The way I would say that, and the way I contextualize that, is that a lot of that was just noise. What was really at stake was, can judges write something into a statute that Congress itself did not put in, just simply because a group of people is despised? And essentially in Bostock, Gorsuch says, no, you can't do that. It can't be based upon past bias. It can't be based upon current bias. If Congress itself did not dare to say it, you can't just assume it's there. That, I think, is a lot of the reason why Bostock is going to be so significant, not just for the LGBT community, but for any historically marginalized minority group. The same trick of reading in extra statutory exceptions, of reading in extra statutory burdens on other minority groups has been used for decades. at least under Title VII, to, again, limit the protections for these minority groups. So that's really, really important. That is why it's so significant. And that is why I think, is just to sort of preview, a lot of courts have been listening and reading Bostock, and both in LGBT cases as well as outside of that context, have been urging that Bostock is a significant doctrinal course correction. We're no longer going to read in extra statutory exceptions. We're no longer going to treat despised groups as exceptional legal subjects. So let me pivot now to sort of a brief preview of my sort of belief about, the power and limits of textualism in Bostock, right? So if you've read Bostock, and you may or may not have, it kind of reads odd for a path-breaking LGBT rights opinion. It's incredibly dry. It's incredibly formulistic. It is not the sort of thing, as I explained to friends, that you'd really discuss or quote outside of court or outside of a legal law school classroom, right? It's just super dry. It's not really quotable, though people have tried. There are good things and bad things about this. I would say, first, the power of it. It's obviously an important course correction in the law, both for LGBT people and non-LGBT people, for the reasons I already described. It also presents perhaps a pathway forward for how progressives can speak to and work with ideological conservatives on the court. It presented an opportunity for staunch leaders of, or presumed leaders of, the legal conservative movement, Gorsuch and Justice Roberts, to come together with the liberal branch of the court and to really push something that had otherwise not been done before. Part of the conservative movement standing up for LGBT rights, and in this case, not only standing up and siding with them, but writing the opinion itself, which is incredibly significant, and getting enough members on the court that, at least under the Trump administration, there would not be enough votes to overturn Bostock without many more justices leaving the court. That is significant. Another power of Bostock that I don't think should be overlooked is, despite it being this sort of dry textualist screed, I think it operates in the vein of sort of a kind of code switching. By this, I mean, it is a way for conservatives to speak to other conservatives in their own language, using their own concepts, using their own modalities, about LGBT equality in a way that they are likely to hear. And that, I don't think, should be underestimated. LGBT advocates for a long time have struggled to get the right messaging, have struggled to get the right community education, have struggled to cobble together the right set of legal theories to sort of justify the ability of LGBT people to exist in this society as equal citizens, right? And much of that has failed for much of our nation's history. Bostock is an example of it actually working, and working, again, by invoking and using and speaking to conservatives in their own language. Whether you like textualism or not like textualism, you cannot dispute that it worked in this instance. Okay, so what are the limits of the textualism Gorsuch deploys in Bostock? Well, there are a few which Katie and Jessica already outlined, and I very much agree with them. One I would like to add to the list is that there are some inherent limitations to what textualism can and can't do when you're contesting LGBT rights. And one of them that I think we see if we look at Alito's dissent in Bostock. Part of what Alito premises his dissent upon is sort of this false history of the existence of LGBT people in American society. One of the arguments he makes is that ostensibly, the vast majority of Americans did not even know that transgender people existed in 1964, and therefore, on that premise, Congress could not have contemplated, the American public could have never intended that transgender people would be protected by Title VII. Oddly enough, the thing that Alito uses to try to justify that is he cites to a 1969 article about a gender clinic that opened at Johns Hopkins, and he claims that that was the first time the American public would have known that transgender people existed. Well, that is absolutely absurd. A historian would do a better job than I to explain why that's absurd. But among other things, and to state the obvious, transgender people have existed throughout history, throughout time, since the very beginning of our republic. And sort of a more pithy or better answer to that is there is extensive coverage of the new technologies of sex reassignment in the United States, both in tabloids and leading newspapers starting in the early 1900s, 1910s, 1920s, 1930s, 1940s, 1950s. Different language was used at the time. Much of it was sensationalized, but Americans at the time knew who transgender people were. They might not have used the language that we use today. They might not have known as much as we know today, but they knew we existed. So why do I bring this up? Well, the formalism of Gorsuch's textualism doesn't necessarily make it imperative for him to correct those false histories, to correct those sort of false, I'd say, cis supremacist histories of transgender existence in the United States. That can be harmful, one, because it leaves Alito's sort of bigoted, ahistoric views unchecked. And it also could present a problem for conservatives later on in other cases, especially constitutional cases, because, of course, with their prevailing methodology being originalism, those false histories can have more power in constitutional cases than they can in statutory cases. I think that that's something to watch out for. And with that, I'd love for us to sort of enter the full discussion.
Absolutely, Ezra. Thank you so much. That was fantastic. So let us go ahead and maybe, I have a bunch of questions of my own, but before I sort of start steering the discussion, I want to give you all an opportunity to, maybe hit on some of what you see as the highlights or points of emphasis, points of agreement, points of disagreement with each other. So I'd love to do that. I do want to add, Ezra, you're quite right. I tried to make a joke about the canon of donut holes the other day. People didn't appreciate it so much. So this is not something you discuss at dinner parties or at donut outings. So Jessica, if you want to start with pulling on any threads, and we'll see where the discussion goes.
Sure. So I'm really curious to hear more from Ezra about originalism, but I want to, I think, respond or pick up on something Katie mentioned, which is about stereotyping doctrine and the way that Gorsuch, in Gorsuch's opinion, Bostock grounded it in but-for causation, which I think is a huge benefit of this opinion. Prior to Bostock, you saw lower courts sort of confused about what role sex stereotypes played in Title VII cases. Is it an independent claim? Is it a type of proof of discrimination? And in Bostock, it is clear that sex stereotypes are a problem when they apply to women in a way that wouldn't apply to men, or vice versa. And that's great. But there are some limitations to thinking about sex stereotyping that way. And one of them is that in Title VII cases, you're going to have to find a comparator. And so a person who says, I was discriminated against for being a mother based on sex stereotypes, that mothers aren't good workers, is going to have to point to a father who was treated worse. You're going to have to point to somebody from the other group. Or you're going to have some evidence that the employer explicitly considered stereotypes, like some sort of quotation from the employer showing that the employer thinks mothers aren't good workers, and not just parents generally. And so that's a challenge. There is a 10th Circuit opinion recently called Frappede versus Affinity Gaming, in which the court applied Bostock to say, you don't have to prove that your employer treated the whole class of fathers better than the whole class of mothers, but you still have to point to somebody who's not a man or a woman, whatever you are, who was treated better than you. And that's difficult because in a lot of jobs, you just don't have employees of the other gender to point to. A lot of jobs are dominated by women or dominated by men. So that's still a Title VII challenge. And there's also the problem that sometimes stereotypes operate in a way that affects both men and women, but doesn't meet that but-for comparator test, like the stereotype that a law firm associate has to be on the job 24/7 and always available. Well, that's a standard that's really bad for women who do the lion's share of care work, but it's also really bad for a lot of men. And it's definitely based on a masculine view of what it means to be a lawyer. But sex stereotyping doctrine doesn't really get at that. And a lot of theorists think that it should.
Thank you, Jessica. Just a quick note for those asking questions in the audience, if you can just add your name to your question, because it just shows me a code and the question, and I would like to attribute the questions accurately when I ask them. That would be helpful. I am keeping an eye on the chat, so if you could ask your questions, I'm copying and pasting it into a Word document and trying to organize things, and we'll see how successful or more likely unsuccessful I am at doing that. Katie, please, if you want to jump in and pull out some threads that you find interesting, respond to Jessica, and so on.
Thank you, Craig. Yeah, I'd like to start by talking just a little bit about stereotyping doctrine and picking up on Jessica's remarks. And then I wanted to come back to just a couple of points that both she and Ezra alluded to in their original remarks. So in terms of stereotyping doctrine, I actually disagree that the limitations that Jessica sees in the but-for situation of stereotyping doctrine are inherent to that principle. So thinking first about the issue of whether we need a comparator or explicit remarks about mothers, Jessica is absolutely right. We have seen some court decisions in the lower courts that have suggested that that type of evidence is required in order for us to, for example, see the very obvious reality that a mother or a parent of small children who happens to be a woman assumed to be uncommitted to the job, that would not have happened to a man, right? Some courts have said, no, you can't just draw that common sense conclusion. You need more explicit evidence in the way of comparative evidence or the like. But I actually think that Bostock itself provides a very strong basis for pushing back against this. In the Bostock opinion, the court treats common gender stereotypes as something that we can recognize as a matter of judicial notice. It does it repeatedly throughout the opinion itself in a way that I think makes clear that we can use our common sense to recognize that the stereotyping of women with small children is, or the set of stereotypes that get applied to women with small children around parenting simply is not, but for their sex would not have been applied to them. And there are a number of decisions in the lower courts that recognize this even before Bostock. There's a great case out of the First Circuit, right, where they say, it's at a minimum a jury question, right? Whether a man would have been assumed to be uncommitted to a promotion because he has a number of small children at home. And I think so for those individual contexts, I think Bostock actually provides considerable support for departing from some of the erroneous lower court opinions that have demanded sort of strict comparators or the like. I want to talk a little bit about the issue of, what about the situation of the law firm, right, where everybody is stereotyped in the same way and required to meet the same stereotype. You could another context where that takes place, right, are employer policies barring traditionally African-American hairstyles and sort of branding them categorically unprofessional. Right, shout out to Wendy Green, who's done lots of fabulous work in this area. Jessica and I actually talked about this issue about a month ago, and it was a very helpful conversation, and it got me thinking about, well, how do we deal with those contexts? And to me, I think the but-for principle still has power here, but that we really need to shift our focus to thinking about the policy in the first instance, and whether the policy as a matter of policy would have been adopted but for the protected class that is affected. And I think in many instances, the answer to that question is no, right? I mean, I think all of us can look at the context of a complete business ban on traditionally African-American hairstyles and say that there is no world in which we can imagine white workers being required to wear dreadlocks or cornrows, right? Like that is the very essence of the policy is based on a stereotype that sort of white professional norms are what is considered professional, or white appearance norms are what are considered professional. So that's sort of my thinking about stereotyping. I did want to pick up on just a couple of other things that Jessica and Ezra said. Ezra talking about the importance of this work and why litigators focused on this for so long. It's both, I think, the important statutory point, but also I think it's important to remember the real human cost that underlay not having a comprehensive system of employment discrimination. When I went out into practice, the job that I held was I founded an employment rights project in the LGBT context. And the reason for that was because there were lots and lots of people who were experiencing discrimination on the ground, and there wasn't representation, right? Private lawyers would not take these cases. They were considered much too difficult to win. And indeed, they were difficult to win for many of the reasons Ezra has pointed out. And, I think it's sometimes easy to forget just how much human cost discrimination has. Losing a job, losing a career can really devastate a person's life in immeasurable ways. And I think it's really important to remember that that's the practical cost here, and that's what this fight was about. Finally, I want to touch just a little bit on RFRA. I agree that RFRA is a concern. However, I think it's really important to remember that we don't yet have a decision from the Supreme Court about whether RFRA applies in the context of cases brought by private litigants. There's a circuit split on this issue. And if the court ultimately decides it only applies to government cases, its outcomes will be, or its potential impact will be really cabined just to cases brought by the EEOC or cases brought by the DOJ. And you can imagine they might not choose to bring those cases. They might advise the private litigant to bring those cases themselves if there was a concern of a religious defense. So making sure we focus on that issue and recognizing that sort of dry technical issue of does this apply to private litigants? It's really important how that issue gets litigated and how it is ultimately resolved by the Supreme Court.
And so actually, I just want to jump in there because Art Leonard presciently asked a question about that very issue. And so he asked, is it most advisable for LGBT people encountering religious-based discrimination to insist on litigating their own cases, given that some circuits say that RFRA only applies when the government is a plaintiff? So Katie, if you want to just jump in.
I would say 100% yes, right? Like I agree with that. I mean, I think that, in the lower court in Stevens, the court ultimately rejects the RFRA defense, but the very fact that it could be raised, right, and the impact it could have had on Amy Stevens not to have litigated that case on her own, I think signals why it's important at a minimum for such private litigants to be parties to the lawsuit, even if the EEOC is also a party.
Thank you, Katie. Ezra, so turning to you and the threads you would like to maybe pull out of the other panelists' points.
Yeah, so like Katie and Jessica, I have lots to say about what everyone has said thus far. I did want to pick out a few points that I think are worth sort of sitting with and thinking about, especially for scholars who are hopefully sort of thinking about contributing more to this area now that there's a whole new area opened up all of a sudden. So one thing that I think it's important to, again, contextualize is sort of what the Bostock trilogy did and didn't deal with. The central question at the heart of all three of these cases, and really the only question the court directly answered, was whether gay and transgender people can be protected by a generally applicable sex discrimination law. Why do I say that? Well, that's really or it should be in most cases, a really basic threshold question, the sort of thing that you deal with on a motion to dismiss, whether this person even has a case that can be heard, right? The court didn't really delve into sort of what sex discrimination is beyond who it can't exclude. And I think that's going to be a really open and really important area for both lawyers and litigators to explore in the coming years. And what do I mean by that? Well, I mean this. We don't yet really know if it is, at least in the court's minds, sex discrimination for, as I think Katie used as an example, a cisgender spouse to be fired because their boss doesn't like the fact that their spouse is transgender, right? The court didn't answer that. We don't know if that's sex discrimination. We don't really know how the court actually feels about sex stereotyping doctrine post-Price Waterhouse. That was one of the questions presented in Harris, but the court conspicuously just decided to not answer it in Bostock, right? So that's an open question. The other thing that I want to sort of raise in there, I think it's really important, especially for people working in gender and sexuality scholarship right now, is I think we don't always appreciate how much the court listens to how the movement and how scholars frame what's important about these cases. And this is what I mean to say here about Bostock. Now, the court very intentionally says throughout the opinion that it's only really dealing with whether transgender or gay people are protected from sex discrimination. Why is that? Mostly because that's how advocates frame the issue. They left off the rest of the LGBT community. They left off Black LGBT people or any other really specific subgroup of the community, right? So the court listened, and that's how they framed the protection. And this does, I agree with Jessica to a certain extent, open up the possibility that employers and other folks, litigating from the far right are going to suggest that non-binary people, bisexuals, I don't know, Black lesbians, however specific you want to be about subgroups of our community, still need their Bostock in order to get protection. Why is that a problem? Well, it took us decades to get Bostock. It took millions and millions of dollars and thousands of hours to try to get this case up and to get this win. We can't expect that tiny little subgroups of the community will have that sort of power and those sets of resources to litigate and get their rights vindicated from the Supreme Court, especially as appointees change, right? So it's something I think that's important. So I'd say keep that in mind if you're litigating these cases or if you're writing about these cases, that you don't necessarily want to lock those subgroups of our community into a straitjacket and imply or suggest that they're unprotected because their exact subgroup was not named by the majority in Bostock, right? It sort of becomes a self-fulfilling prophecy of the thing that we fear. The other thing that I think is really, really important to think about in these cases, and think about as sort of scholarship is going forward. And I know that Katie and I think Jessica and I at very different points in time have had discussions about this. Depending upon what stage at which the court decides to pick up these cases, they start talking about what constitutes sex discrimination in really, really different ways. So I know Katie, when I was working on a case in the 10th Circuit a couple of years ago, we had a long discussion about this, that a lot of the scholarship and a lot of the opinions out there on what constitutes and doesn't constitute sex discrimination are really concerned with the threshold question. Is this group protected? Not what is sex discrimination, right? I think it'll be really interesting to see in coming years as more LGBT cases are getting past that threshold, to see how courts and how juries, dare I gasp and hope, sort of identify what matters in the workplace. What are the things that you can and can't do? I think Jessica alluded to this when you said it's a recent opinion about misgendering of a transgender person constituting sex discrimination, which I completely agree in certain circumstances. So I think that'll be an interesting open area, right? So what actually sort of moves the dial and what constitutes a statutory violation. No longer just the question of who's protected, who's not protected, but what sort of conduct are we going to say shouldn't be permissible in the workplace or in other contexts.
Thank you very much for that, Ezra. By the way, I should note that my millennial card should be taken away if I ever had it, because Art Leonard, Nancy Polikoff, and Mark Wojcik gave me the technical information to see everyone's name. So I apologize for that. And if folks want to ask more questions, I will see your names. But so far, I've gathered the questions and organized them. And to that end, I'm gonna start out with the first question, which is really sort of springboards off something Ezra said, which is thinking about other arguments and other strategies and their fate as a result of Bostock. And I'm going to sort of just expand on that a little bit. So I'm thinking about constitutional cases, right? So on one hand, we could think about still trying to go for a suspect scrutiny strategy. It's unlikely with this court, it didn't even work with Justice Kennedy, right? So should we even bother? Should we just try and even in the constitutional context, talk about this, about SOGI discrimination as sex discrimination. Second, I'm thinking about the disability law strategy in the transgender context. One little tidbit was, in our brief, which focused on the history of legislative perception of transgender discrimination. One argument that we wanted to put in and we sort of debated over was the fact that when Congress introduced the transgender exception into the ADA, that same subcommittee was also considering the amendments to Title VII. And so our point was, well, if Congress wanted to exclude transgender individuals from Title VII, it was thinking about transgender exceptions at the same time. The same people were thinking about it, right? But we were very worried about the implications of using that argument in this case, because we were worried that a stray comment by the court could torpedo the disability strategy. And now the query is, do we even need that strategy? Then, another question, I'm just throwing these all out as a sort of grouping of questions, and you can pick on what you like, is thinking about future legislation. So Mark Wojcik asks, So can you give us one or two specific talking points for members of Congress on why we still need ENDA after Bostock and the cases extending Bostock to other federal statutes? And one sub-query of mine would be, do we still need ENDA? And then the final thing is, I think about Bill Eskridge's typology, right, of type 1, type 2, type 3 laws. Type 1 laws, he says, are laws that discriminate against individuals based on their sexual orientation. Type 2, discrimination against individuals based on their sex, a sort of Bostock argument, but one could maybe argue that the type 1 laws now sort of begin to collapse into the type 2 laws. And then finally, he talks about type 3 laws that are laws of seemingly general applicability, but which have a disparate impact on the LGBT plus community, including, for example, laws against public sex. And so just sort of thinking about, if we want to go in the area of addressing those laws, to the extent we don't take an assimilationist approach to LGBTQI equality, the question would become, what's the strategy? Because Bostock doesn't seem to get us there. Actually, one last question, which is thinking about, which is the springboard that Ezra, I think, gave me, which is I also think that different arguments position different subgroups within the LGBT community in different ways, right? And I think that, for example, had we just doubled down on the suspect scrutiny argument, one could imagine a world in which transgender individuals would have kind of been left off the bus, because in many ways they are the powerless group, I think, sometimes within the LGBT movement that Ezra referred to. On the other hand, using the sex discrimination argument, I think, gave trans rights more leverage, because in some ways, think about the 1557 rule, right, in the Obama years, it seems more clear that sex discrimination applies to trans individuals, and at least according to some, less so to LGB individuals. So thinking about those future arguments in reference to the positionality of the subgroups within the LGBT movement, trans and other groups might also be helpful. So I'm just going to throw that all out at you, and I will sit here and eat my donut holes.
I'd like to say something about the importance of focusing on Congress and legislation, especially in this moment where Democrats have now won a majority of both chambers and the presidency. I think we need to focus on legislation, particularly the Equality Act. And my talking point in favor of the Equality Act would be that Bostock doesn't necessarily cover the entire LGBTQ community. And so we need a legislative solution that would do that. And I want to also go back to a point that Katie made about policies that might be generally applicable, but that were intended to discriminate against a group. And an example of that is hairstyle policies that don't allow traditionally African-American hairstyles in the workplace. One thing I think is so great about Wendy Green's work is that she's focused on state level legislative reform, the Crown Act, that would allow these policies. And that's because courts are really bad at seeing discriminatory intent behind a policy. I mean, they couldn't even tell the Muslim ban was a Muslim ban. And hairstyle policies are another example. The 11th Circuit really struggled with it. And in a decision called EEOC versus catastrophe management, they said, well, we're listening to all your theories, scholars, but you scholars say this and you say that, and we can't make heads or tails of it. There's no direct evidence here that this policy was motivated by discriminatory animus against Black people, and so we throw up our hands. And I think we got to seize this moment, it may be a short one, and enact laws like this that are going to resolve these sort of situations where you have a generally applicable policy motivated by discriminatory intent. There's a lot there in your question. I'm going to let the other panelists talk about it.
Go ahead, Katie.
Thank you. So I want to jump in and just start by saying I 100% agree with Jessica that I think thinking about legislation and the importance of legislation, not only at the federal level, but at the state and local level, is really important. I want to pull out another insight that I think Professor Green's great work really can allow us to take away, which is that it's important to build a movement, right? That legal principles can play some role, but we also need to be spreading the idea, right? The idea that banning all traditionally African-American hairstyles is discriminatory has gained purchase. And she has a hashtag, right? Free the hair. So it's all of these things, I think, that are needed. And I think that we will start to see that spill over into the courts, right? As the courts come to see this as discrimination, as they hear a discourse of this as discrimination, they will be able to see more transparently the ways in which these policies would not be adopted but for the race of those affected. And I would frame it in those terms, not in intent terms. I wanted to come back to the Equality Act. I also 100% agree with Jessica here that the Equality Act remains critically important. I want to take a slightly different focus, which is the reality that what workers want, what folks want in reality is not a lawsuit. They don't want to be able to bring their claim to court. They want not to experience discrimination to begin with. And the simple fact is that having a clear, unambiguous statement from the federal government, from Congress, that this type of discrimination is impermissible is far more likely to effectuate that goal than a judicial opinion alone. It's also the case that many of the most critical open issues of Bostock, like the application of RFRA, like how transgender folks are going to get treated in sex-segregated spaces, are addressed in the Equality Act. So I think it remains critically important for people to not think that that is a done deal, that we don't need it anymore. And I'm also going to go ahead and conclude there, even though I know I didn't answer some of your questions, Craig, because I want to make sure to leave time for Ezra.
Absolutely. Thank you, Katie. Ezra, so you've got to answer all of the remaining questions, just so you know. That's how it works.
Fair enough. Fair enough. So I'd like to pick up on the Equality Act. So I'll be the contrarian on the panel. I do not think that the Equality Act is currently written is a good piece of legislation, and I do not think it is the right solution, especially in a post-Bostock moment. This is why. The Equality Act is sort of this ever-changing statute that's been called many, many different things over time, is essentially was intended and has always been designed to be sort of a band-aid to fix the exact problem that Bostock solves, which was the idea that LGBT people need to expressly be stated as protected subjects to be protected by generally applicable non-discrimination laws in the United States, specifically under federal law, right? That is what the Equality Act was more or less designed to fix. That is how it's written. Those are the problems that it tries to solve. It incidentally tries to add sex discrimination, defined very broadly, to other pieces of federal law where sex is not currently protected status. I do agree that that should be done, right? Why do I not think the Equality Act as currently written should be passed? Well, I see fully well, just like Jessica and Katie see, that this is an important strategic moment, right? If Democrats hold, the House, the Senate sort of barely as a technicality, as well as the White House, this is the time to push through path-breaking civil rights legislation. If there was ever a time, this is the moment to do it. I agree with that. I think, however, we need to think bigger than the Equality Act. We need to think beyond Bostock. We shouldn't be trying to solve the problem that Bostock solves. We should think bigger. What do I mean by that? Well, there are lots of problems with Title VII. There are lots of problems with all sorts of bits of civil rights legislation at the federal level where we know full well, and many of you who are in the audience today know full well, they underprotect people or they're just plainly written poorly, and courts have been dealing with them for years. Among other things, Title VII doesn't protect the vast majority of workers in the United States because of its requirement for the size of the workplace you can go after. It has to be 15 or more employees, right? Because of all sorts of technicalities. Other pieces of federal legislation, like the Federal Housing Act, don't cover lots of households in the United States where people are being unfairly denied the ability to rent or buy homes, get mortgages, things like that, because they were narrowly written at other periods in time to get passed, and that's the hurdle way to get passed, right? I think this presents an opportunity for us to fix the laws for everyone. And in that respect, I'd also like to bring up this, that we often don't talk about in LGBT spaces, but we should. The Equality Act, though openly supported by a coalition of civil rights organizations representing lots of minority groups in the United States, has not behind closed doors been supported by the vast majority of minority groups, rights organizations in the United States. Why? Because they thought that the Equality Act pushed for changes that were too oriented to only fixing LGBT problems and weren't fixing problems like things like the Crown Act is trying to fix, among other things, right? I think the Bostock moment, this post-Bostock moment, presents an opportunity for us to form new coalitions, for us to form new kinds of alliances, and to try to get legislation that helps broader communities of historically marginalized groups. LGBT people are not the only people who need help. We're not the only set of folks who need federal laws to change. And we should really, I think, in this moment, again, be forming coalitions where we try to fix bigger problems than just what Bostock already solved.
That's super helpful. Oh, yeah, I saw Katie's. Yes, please.
Yeah, I just wanted to pick up a little bit on what Ezra just said, because I think it's a super important point, right? We can look around and see that the existence of formal equality protections does not guarantee equality on the ground, right? That we have had a very, broadly applicable set of civil rights law that is applied to racial justice for at least since the 1960s, right, and arguably dating back to Reconstruction. So I do think that in this moment, thinking about the, building coalitions, thinking about what are the problems that affect sort of across the board different subordinated groups, thinking about issues like criminalization, right, which is an issue that affects many LGBT folks, especially trans folks, but also affects people of color, people with disabilities, right? I do think that there is both within the narrow realm of employment discrimination, thinking about how to strategize, how to get rid of the negative doctrine there, but also more broadly thinking about cross-cutting alliances on important issues. I totally agree with Ezra. I think that's a really important point.
Absolutely. No, thank you so much. That was fantastic, and I feel there's so much more to discuss there even. But we've got just a bunch of other great questions, and one actually, again, Ezra provides me all these wonderful springboards, which is just thinking about the effect of these arguments on other groups. So Art pointed out in the chat that the Equality Act also included sex discrimination provisions for public accommodations, which of course we do not currently have. And then June Carbone asks, what do you see as the impact of Bostock on things like gender-specific dress codes or women's sports? So if you could maybe speak to that and expand on those points, which I think you picked on the beginnings of a little bit, that would be helpful. And I'm just going to throw that to the group, and whoever wants to answer that can answer that.
Well, I'll talk about dress codes. There are already a couple lower court decisions holding that applying sex-specific dress codes to transgender employees in ways that force them to dress not in accord with their gender identities is suspect. I would hope that Bostock's but-for logic goes farther to challenge dress codes as applied to anyone. So prior to Bostock, there's this infamous Ninth Circuit en banc decision called Jesperson versus Harrah's Casino, where the casino told a cocktail waiter there, her name was Darlene Jesperson, that she had to wear makeup, even though she had been doing her job for decades, not wearing makeup very successfully. And the casino defended that policy by saying, well, look, we have this rule that women have to wear makeup, but men have to keep their hair short. And so our dress code applies equal burdens to women and men. And the Ninth Circuit said, without some evidence that makeup is more expensive or onerous, which the litigants didn't provide, then we can't find any discrimination here. That doesn't make any sense under Bostock's but-for analysis, which doesn't ask whether men and women are equally burdened as groups. It asks whether, but for the fact that she was a woman, would Darlene Jesperson have had to wear makeup? And the answer is no. If she had been a man, she wouldn't have had to wear makeup. And so I think that Darlene Jesperson should have been able to comply with the men's side of the dress code and keep her job. And that should be the way that courts see it. Now, whether courts will extend Bostock that way, I'm not sure. I'd rather have legislation that tells them what to do, because I'm worried that now a majority of federal court judges have been appointed by Republican presidents, and some are openly anti-LGBTQ. And unlikely to be sympathetic to plaintiffs like Darlene Jesperson, whatever her identity might be. But I think that's the way the law should go on dress codes.
Absolutely. And I know that there was some conversation as to whether the Supreme Court dress code should have been complied with in Bostock, which I thought was just fascinating as someone who, is interested in the inner workings and basically gossip in the Supreme Court. I should also mention that, if you look at the Jesperson decision, again, just trivia, Jenny Pizer is listed as the first counsel on the case in the brief, and Jenny, of course, is a longstanding LGBT activist. And then the decision was written by the first female chief judge of the Ninth Circuit, and Alex Kaczynski was in dissent. So it just sort of gives you a sense of the vagaries of the situation. All right, so continuing on with the list of questions, so again, thinking about the future, David Simpson asks, to the extent there is some tension between an increasingly conservative federal judiciary with recent appointments in the broad language of Bostock, going back to the point Jessica did just make, including but for cause, etc. What tools do you expect courts to use to pull back on the reach of Bostock? Do you expect courts to, for example, double down on looking for perfect comparators, as some circuits do, and discounting plaintiffs' claim for lack of evidence of but for causation, if such comparators don't exist for a particular employee? And I should note that in the chat, there's been a robust discussion by Dave Cruz, Art Leonard, and others on the issue of comparators. But I know that there are some scholars of comparators here, and so I'd love to hear your perspective on it. Katie, go ahead.
Yeah, I mean, I would say two things. I think first of all, anybody who knows anti-discrimination law knows that the lower courts' application of anti-discrimination law, specifically in the employment discrimination context, but often spilling over beyond that, is a mess, right? They are not focused on the bottom line question of whether a reasonable jury could find that but for the plaintiff's protected class status, this adverse outcome would not have occurred. Instead, they're down in the weeds with these sort of hyper-technical questions of, was that comparator appropriately close under these 10 factors from circuit precedent to satisfy the prima facie case of McDonnell Douglas. And here is where I think it is so critical for progressives to lean hard on textualism and to not permit that type of contra-textualist discourse to persist. I think that it's very easy to see that virtually all of these doctrines have no founding in the language of Title VII. The idea that you have to identify a particular comparator that meets 5 different criteria in order to show that because of your sex or because of your race you were treated differently is simply wrong. It's not in Title VII. So I think that recognizing the terrain we're going to be faced with, recognizing that there are going to be some of these judges who are textualists of good faith, just as Justice Gorsuch proved himself to be a textualist of good faith, as Justice Scalia sometimes was a textualist of good faith, right? And making the arguments that are going to reach those judges in the place where they sit, I think is important.
Absolutely. Thank you so much, Katie. And in many ways, the point you made about textualism anticipated a question that Stephen Rich asked that I just saw, which was, what should our concern be that judges might adopt an intentionalist, purposivist form of interpretation in order to move away from Bostock and some of the consequences with respect to normative practices like, dress codes or segregated bathrooms, etc. So that was super helpful. Okay, so. The next question has to again do, and I think, Katie, you provide a great springboard for that, for the textualist, thinking about Price Waterhouse. So Price Waterhouse cannot be described, I think, and I agree with Goha Krishnamurthy, who asked this question, as a textualist decision. Is Price Waterhouse articulable in textualist terms, or is it not?
I mean, I can jump in again. I think it is, and I think that Bostock gives us the textualist hook, right? I mean, I think Bostock itself recognizes that sex stereotyping is a textualist principle, right? It recognizes that, the court has made clear that the language because of sex, that as a matter of its textualist reading of that language, actions that would not have been taken but for the sex, race, disability, et cetera, of the individual are prescribed. It's treated that as a textualist principle. And the court clearly links that principle to stereotyping, right? We've had some discussion and debate here today about the limits of how far that principle can reach, whether it can reach all stereotyping cases, but I think for many core stereotyping cases, that provides a very strong and clear textual hook for the stereotyping principle.
Absolutely. So I'm just going to maybe, go and think about the justices a little bit, right? So what do you make of Justice Roberts? So I thought that, we were also hopefully going to get Justice Gorsuch. I was skeptical about Chief Justice Roberts because, as you know, he famously asked the question in Obergefell as to the sex discrimination argument in oral argument, and he seemed to be unmoved and dissented in Obergefell. So I thought that the ship had sailed with respect to him. And do you think that this was just a strategic ploy by Chief Justice Roberts? And as long as we're talking about the justices, I'm sort of curious as to, Justice Alito positions himself as a mini Justice Scalia, as some of our colleagues at other schools call him Justice Scalito, right? And some of his language, which he uses in his dissent, sounded very Scalia-esque, right? It's like a pirate ship, the majority opinion. It sails under a textualist flag. And then he sort of adopted the famous Scalia method of doing strike-throughs in his dissent, which Scalia famously used in Windsor to, from his perspective, disastrous effect because the lower courts kept citing his dissent, saying, well, so clearly the Supreme Court wanted to endorse marriage equality at a constitutional level. So I guess my two questions are, what do you make of Chief Justice Roberts joining the majority? And second, what do you make? What do you think Justice Scalia, the author of Uncall, would have done here? And Ezra, do you want to sort of jump in?
Sure. I think looking back before we actually got the opinion, it was highly predictable that Justice Gorsuch would both write it and it would be this odd sort of, again, textualist screed. That was just where he was going. He had a previous opinion when he sat by designation on the Ninth Circuit that he very clearly wrote, despite it not being attributed to him. This had long time coming been his position on Title VII. That's just how he saw it. I think as to, Justice Roberts, he's no champion of LGBT rights. I don't think anyone in their right mind would ever suggest as much. But I do think over the last few years, in a variety of cases, we've seen that he has a deep vested interest in making sure that the court is seen as institutionally legitimate. I think he understood just how significant this particular opinion was. I think he understood the genius behind how Gorsuch wrote this opinion, how he was able to speak to conservatives, again, in their own language and communicate exactly what this, I think he calls it a simple but momentous message, means about the law and about what American society is going to do with LGBT people going forward. And Roberts just didn't want to be part of anything that called into question that, and didn't want to suggest that by replacing a few more justices on the court, this opinion was going to change, right? That's why he's there. Do I think there's anything that this really says about Justice Roberts going forward in LGBT cases? Well, I think it could signal that to get Roberts, we might need to, as advocates, as scholars, make arguments in conservative terms, that might be the thing he needs to hear, right? I think it might mean that maybe, next year, in the coming years, Justice Roberts might think differently about a more capacious understanding of what sex discrimination is and isn't in constitutional cases because of what Bostock says. Again, do I think in other cases where we're not dealing with sex discrimination, where we're not dealing with these sort of textualist statutory cases, that he's going to be a champion out there, writing the opinion and whipping up the votes? Absolutely not.
So, and that actually is a helpful way to conclude our panel. We've got 15 seconds left, and I look forward to the future of the movement and thinking about the way these arguments will play out, which really is the point that Ezra ended on. So, thank you so much for joining us for this fantastic panel. Thank you to our panelists, Jessica, Katie, Ezra. Thank you to Jack Harrison for pulling the panel together and doing so much organizing and being the fearless leader of the section this past interesting year. And thank you to all of you for attending this panel during even more interesting times. I want to point out that the year officially doesn't end until the 20th. So until then, I wish you all very well, and I hope to see you in person at AALS next year. I will note that my plans this year to have a little cocktail party for the section members, which is what I'm very good at, was foiled, and clearly all of this was just to spite me. And I hope that next year we'll be able to have a wonderful time together. And I look forward to seeing all of your faces and seeing all of you in person. Thank you again, and have a wonderful rest of AALS.